So we have some important news coming out of the Supreme Court in the next big firearms and ATF overreach challenge that the court is reviewing. So let's break down what is happening. Now, really quick before we jump into this video, if you agree that the ATF needs to be abolished, go ahead and hit that like button and subscribe. Also, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. Not only do they make amazing supplements and products that can help you along your journey when you're trying to get healthier, but also they are pro-freedom, they are pro-2A, and they support what we talk about and do here on this channel. So again, if you want to get amazing supplements and support a company that's pro-America, check them out using the links down below. And thank you again to 1st Phorm for sponsoring and supporting this content. Now, as I mentioned in the intro in this video, we have some important news coming out of this case, which is going to be the next big firearms and ATF overreach case that the Supreme Court is set to review. The Supreme Court recently granted review to the ATF's frames and receivers case called Vanderstock versus Garland. The case is now set to be heard and decided by the United States Supreme Court during the court's next term. And even more important, now the case has the benefit of the Supreme Court and their recent ruling in a 6-3 decision in the Cargill case. And again, that struck down the ATF's overreach where they defined bump stocks as actual machine guns. The Supreme Court struck down the ATF's bump stock ban, and now the ATF's frames and receivers rule will likely suffer the same fate. But the ATF still is trying desperately to protect their 80% rule, and they're trying to avoid that Cargill decision from being used in this case. And they say right now that that 6-3 decision in Cargill does not impact what is going on with the Vanderstock rule. And now, even more important, the Supreme Court has set the hearing and the arguments in this case to take place during October 8th. So October 8th is when the Supreme Court is going to hold oral arguments in this case. Originally in this case, the original plaintiffs, FBC and Tactical Machining, sought preliminary injunctions to halt the enforcement of the ATF's new rule while the case made its way through the process. On review, originally Judge Reed O'Connor, he granted a limited preliminary injunction against the ATF, which effectively prevented the ATF from enforcing their rule against Tactical Machining and their customers. Now, after that, there were other companies like Blackhawk Manufacturing Group, also known as 80% Arms, that sought to intervene in the case as named plaintiffs. They were allowed into the case as named plaintiffs, so 80% Arms, one of those big companies, is also fighting in this case. They're one of the plaintiffs, and they also got similar injunctions, preliminary injunctions, which protected their company and their customers. Now, after the preliminary injunction stage, the plaintiffs sought to win the entire case by asking for a motion for summary judgment. And in response, Judge O'Connor did grant the motion for summary judgment, and the relief he granted was vacating the frames and receivers rule in its entirety nationwide. Well, of course, the ATF was not going to let that summary judgment sit, so they filed an appeal up to the 5th Circuit Court of Appeals. And then that led the ATF for the first time to go up to the Supreme Court on an interlocutory emergency basis, again for the first time, seeking for a halt of what the lower court did. And again, what ended up happening there is the Supreme Court did side with the ATF. They issued a 5-4 decision, essentially putting a stay on that lower court enforcement of the summary judgment. So that was kind of the first roadblock in this case where you had the Supreme Court step in a little bit in favor of the ATF. Now, after that happened, what ended up happening was some of the plaintiffs here, like 80% Arms and Defense Distributed, went back down to the lower court judge, Judge O'Connor, and sought an emergency motion for a new preliminary injunction. They asked for Judge O'Connor to put back in place his prior preliminary injunction that was more limited in scope, that only protected the company and customers. Essentially, they said, yes, the Supreme Court said that you could not issue a nationwide vacatur of the rule, but Judge O'Connor, you can still keep this more limited form of relief in place. And Judge O'Connor agreed with them and issued once again a more limited injunction. And again, the ATF didn't like that. They went crying up to the 5th Circuit. The 5th Circuit denied relief in that. And then they went up to the Supreme Court again on an emergency basis. And the Supreme Court agreed and once again issued an order striking down what Judge O'Connor said. So through those two emergency orders from the Supreme Court prevented any positive relief in this case while the summary judgment was being reviewed by the 5th Circuit. Now, the 5th Circuit recently did decide on the merits of this case, and in their decision, the panel there partially upheld the lower court's decision, which struck down the entire ATF rule, found that it was invalid, that it did not actually align with the statutory text, and was overreached by the ATF. That decision by the 5th Circuit 3-judge panel agreed again with the lower court judge. The only thing that they found issue with was the nationwide outright vacatur of the rule for everyone nationwide. They said that maybe it should have been a more limited in scope because of what the Supreme Court said in their emergency orders. So that was the only thing they found issue with that. But ultimately, they still did strike down the rule, finding that it was invalid. Essentially, because of that Fifth Circuit decision on the summary judgment, the ATF had a hard choice, but they decided to roll the dice and go directly up to the Supreme Court. But recently, like I said, we got a ruling from the Supreme Court in the Cargill case, and in a 6-3 decision, they struck down the ATF's overreach with bump stocks, finding that what the ATF did not align with the actual definition of a machine gun in the GCA, and they found that the ATF overstepped their authority, struck that down, and that sent a big signal to all lower courts and the ATF about how the Supreme Court is going to handle all these ATF overreach cases going forward. Then you also had the striking down of Chevron deference, which didn't play a big role necessarily in Cargill, didn't play a big role really in this case, but again, it's a strong signal to other agencies like the ATF that the Supreme Court is just done with agency overreach. Now, you may be asking yourself, how does the ATF address that recent Cargill decision? How do they respond to it here in this petition? Well, in the response, the ATF addresses it really by just avoiding it. In fact, they don't even really reference it at all. If anything, they only referenced it one time in the entire brief. So really the ATF strategy right now with Cargill is to try to ignore it and say that it does not apply here to the unfinished frames and receivers rule. Now, I don't think that strategy is going to work at all, and it's going to get even harder for them now that, again, this was granted review from the Supreme Court, so the Supreme Court is going to review this 80%er rule, and they're moving it towards a hearing, and there's going to be oral arguments now that are set to take place on October 8th. The ATF is going to be forced to have to answer how Cargill and the Supreme Court's decision in that case is going to impact the ATF's 80%er rule. And it's going to be very interesting to see them squirm during those oral arguments. And I suspect that the ATF won't have a ton of great answers. They will try to say, well, bump stocks in the Cargill case dealt with a different section of federal law, dealt with machine guns. This deals with what qualifies under the definition of a firearm. So they're going to try to probably distinguish it that way. But I don't think that's going to fly because generally what this still involves is ATF overreach, redefining things however they want, trying to cram things into definitions that were never intended to actually apply. So the ATF is trying desperately to save their frames and receivers rule, but really after Cargill, in my opinion, the writing is on the wall. Now, this is something we're still going to be wanting to watch very closely, and now it's moving towards the oral arguments on October 8th, and we're going to be listening to those and waiting for those anxiously because, again, it's going to be very interesting to see the ATF squirm in front of the Supreme Court trying to justify this second rule. And I think for the second year in a row, where we're going to get is a decision by the Supreme Court striking down ATF overreach, which is a huge win. So as things develop, as we get more information, I will let you guys know. Also, if you like this video, and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.